The broadcast is now starting. All attendees are in listen-only mode.
Good morning and welcome to the Agency Update and Changes webinar. Thank you for joining us for this last webinar in the 2015-2016 Maryland Association of Realtors Webinar Thursday series. This is one of your many MAR member benefits. You can view the entire schedule on our website at mdrealtor.org under Top Destinations on our homepage. We are recording today's webinar and we'll be posting it on our website next week. If you haven't yet, take a look at the video we released in early October on this agency topic as well. It has a lot of good information on the changes that were enacted early October to agency in the state. The video is accessed by also visiting our website. Our presenters this morning are Kathleen Dartez, MAR's Director of Legal Affairs, and Colette Massengale, one of our staff attorneys. This webinar will provide you with practical insight of the recent changes to agency law in Maryland and explain how you must work now with your clients and customers. Something we're going to try a little bit different for this morning is to make this webinar a little bit more interactive for everyone. There will be a poll question we're going to launch about midway through the presentation. You'll need to be in front of your computer to answer the question. And if you're with a group watching this, as we know many of you are, take a vote and please submit just one response. Also, please feel free to ask questions throughout the presentation. There's a box on your screen where you can submit a question to us, and we'll get those answered for you. Let's begin.
All right. Thank you, Melissa. And thank you, everyone, for joining us this morning. I know it's, this is Kathleen Dartez, by the way. Thank you for joining us this morning. I know it's a very busy week right before Christmas and Hanukkah, and we appreciate your time, and we will be respectful of your time and try and stick to the hour that we have allotted as much as possible. Okay, so before you see the agenda, what we are going to cover during this morning's presentation, first we're just going to give a quick overview of the changes, which I think hopefully everyone is aware of at least somewhat by now. Then we're going to go through some more detailed information. As Melissa had indicated, I think with some of the changes, the significance and difference between a customer and a client has become more important, so it's kind of back to basics to think about some of those things. So we are going to go into a little bit more detail about sub-agency, the definition of sub-agency, what it means to be a sub-agent, the requirement for having a written brokerage agreement, and again, with respect to customers and clients, understanding confidential information and ministerial acts is becoming more important as well, too. So we want to make sure you all have an understanding of that. And then we're going to go through dual agency and the agency disclosure requirements, excuse me. And then at the end, we have a series of FAQs that we are going to go through. Some of them are questions that come up in class. Some are questions that have come up on the legal hotline, so we'll go through those. And as Melissa had said, you are welcome to ask questions as we go through the presentation, and we'll try to address them as well. Okay, so go first, I guess, the summary of the changes. Basically, there are really three things that changed. The disclosure requirement has changed. Now, from October 1st forward, you are only required to disclose to unrepresented parties, meaning disclose, that means using the understanding whom form. You only need to present that to unrepresented parties and have them sign it, acknowledging that they understand who you represent. The other change was the open house sign, which I think everyone loves that change. It's pretty straightforward. Previously, at an open house, you had to sit there, and depending on what type of questions someone was asking, you may or may not have had to have them sign the understanding whom form. So that has gone away completely. The Maryland Real Estate Commission issued an open house sign that has to be conspicuously displayed during an open house. And as long as you conspicuously display that sign, printed in color, you will be in compliance with the law, and you do not need to use those understanding whom forms at an open house as well, which I think most people are okay with that one as well. The third change, and probably the most significant change, is that the concept of presumed buyer agency has been eliminated. So that is what has kind of given rise to the sub-agency, again, making sure we all understand sub-agency and the role of a sub-agent with respect to their client and a customer. So that's what we're going to really focus on primarily during this discussion. All right, so as a preliminary matter, the law itself applies in certain situations, and primarily it applies for the sale and lease of real property improved by 1, 2, 3, or 4 single-family units, which if you are residential agents, that's pretty much going to be all of your transactions, sale or rental of townhomes, condos, single-family homes. It also applies to unimproved real property that has been zoned for residential use. So if you're selling, unimproved land, vacant land that is zoned residential, these requirements would also apply in that situation. And it also applies to residential leases of more than 125 days. So be aware that if you're doing short-term rentals at the ocean for 3 weeks or 2 weeks or something, this does not apply. But residential leases of more than 125 days, these laws apply. All right. So let's get started. I guess the elimination of the concept of presumed buyer agency means that sub-agency is basically a thing again. So let's make sure that everyone understands sub-agency. The definition of a sub-agent is a licensed real estate broker, licensed associate real estate broker, or a licensed real estate salesperson who is not affiliated with or acting as the listing broker, right? So you're not the listing broker or affiliated with the listing broker. You are not a buyer's agent. You have an agency relationship with the seller or lessor, and you assist a prospective buyer or lessee in acquiring the real estate for sale or for lease in a non-agency capacity. That's kind of the key there. The buyer that you're dealing with or the tenant you're dealing with, you are working with them in a non-agency capacity. The sub-agent works for a real estate company different from the company for which the seller's agent works. So you're going to have two different companies. The sub-agent can assist a buyer or tenant in purchasing or renting, but his or her duty of loyalty is only to the sellers or landlord. And that's one of the key things that has to be communicated to a buyer. If the buyer is not willing to sign a buyer agency agreement, then you don't represent that buyer, and they need to understand that you are a sub-agent of the seller, meaning that you represent the seller, and your duty of loyalty is to the seller, not to the buyer. Okay. Another key point, and this is the most significant change probably from your perspective, is with the elimination of the presumed buyer agency, you must have a written agreement in place with the buyer. You must have a buyer agency agreement signed by the buyer in order to represent that buyer. That's really the bottom line, what it comes down to. And this part has not changed. Brokerage agreements have to have a definite termination date that is effective automatically without notice from the client. And that, of course, can be negotiable and flexible. As we've been doing classes, I think some people are finding, if they explain to the buyer that we can give you the right to terminate in 24 hours, if you are unhappy with my representation, you can terminate this agreement tomorrow. That it seems to be working for some people, makes the buyer perhaps a little bit more comfortable in signing a document. That, of course, is up to you. You can talk to your broker and work on script or sales techniques, a way to explain the buyer agency agreement, but negotiating the termination date is one thing you might want to take a look at or consider if you have someone who is hesitant to sign the agreement.
Yeah, it can also be property specific too, isn't that right, Kathleen?
Oh, that's true. That's a good point too. Thank you, Colette. Yes, if the buyer wants to go look at one particular property or two particular properties on some Saturday afternoon, but they don't want to commit for a 6-month relationship or 3-month relationship, you can limit the buyer agency agreement to just one property or two properties as well. And again, some agents are having some success with that. If a buyer is perhaps hesitant to sign something broadly, they might be more comfortable signing it just limited to one or two specific properties. So thank you, Colette. That's a good point.
Great.
Okay, so confidential information, again, this with respect to the role of a sub-agent versus a buyer's agent or presumed buyer's agent. Confidential information is important as well, because remember, with there's a difference with a customer and a client, and you have to maintain confidential information for your client, which again, if you are a sub-agent, your client is the seller. So you have to keep in mind what's confidential information and what am I able to share or not share with this buyer who I do not represent, this buyer customer. So let's go through confidential information. This should be pretty straightforward because this hasn't changed significantly. Confidential information includes the fact that the seller or lessor will accept a price or rent less than what's in the listing agreement, or will accept terms other than those contained in the listing agreement. Okay. Confidential information would also include, on the buyer side, that the buyer or lessee is willing to pay a price or rent higher than what they had offered, or will accept terms other than those contained in the offer. Okay. Confidential information also includes the motivation of a buyer, lessee, seller, or lessor, or the need or urgency of the seller to sell, the buyer to buy, or lessor or lessee to lease the property. So again, motivation or their urgency is also considered confidential. Okay. Confidential information also includes any facts that led the seller to sell, the buyer to buy, or lessee or lessor to lease, and also any facts that relate to the negotiating strategy of a client. So this, again, is going to be important, and you need to understand if you're talking to a buyer, you know, if they don't sign a buyer agency agreement, you have to remember that you represent the seller. You have to be careful. You can't share any confidential information of the seller. You know, this particular information, if they're in a hurry to sell, if they're divorcing, whatever it is, you have to keep that information confidential if you're acting as a subagent. All right. This is a key, too. Sometimes people forget this or may have overlooked it, but I know everyone learned it in the pre-licensing and is aware of it on some level, but it's important to focus on it as well. A licensee may not disclose confidential information about the licensee's past or present client or a past or present client of the licensee's broker. Remember, the brokerage agreements, you know, the listing agreement and the buyer agency agreement are between the client and the broker. So the confidentiality, the duty of confidentiality, it's basically forever and ever. Amen. So keep that in mind as well. Okay. And again, now, Ministerial Act is another thing that you may or may not think about on a regular basis, but with the elimination of presumed buyer agency, this is going to be kind of important, again, to understand this. If you have a buyer who doesn't sign a buyer agency agreement, they're not your client, excuse me, they are a customer. So for a customer, you can perform ministerial acts. So let's go through this definition or explanation of ministerial acts. Ministerial acts are performed on behalf of a client, this is the client, before and after the execution of the contract of sale or lease. Ministerial acts could be assisting another unrepresented person to complete or fulfill a contract of sale or lease with the client of the licensee. And a ministerial act would not involve your discretion or exercising your independent judgment. So an example of that would be scheduling an inspection. I've been asked a couple questions on the legal hotline and in classes also about certain activities that a potential listing agent or a potential buyer's agent might do for that person in the hopes that someone would become a client. For example, I spoke with someone yesterday who wanted to was thinking about becoming the listing agent or hoping to become the listing agent. The seller wasn't quite ready to sign a listing agreement and was thinking about selling in the spring. So the question was, well, what can I do for this seller? Can I talk to the seller? Can I tell them, you might want to paint this room, or just offer some general suggestions? Can I put them on a list and maybe send them emails with comps in the neighborhood, so they see what other homes are going for? And that kind of thing is fine. That's a perfect example of ministerial act. So you could do those with a potential client, even if they haven't signed a listing agreement with you yet. You do whatever you're going to do, constant contact, send them emails, call them periodically, sort of you would work on that relationship, and then next spring, I guess when they're ready, then you would meet with them, do the formal listing presentation, and have them sign the listing agreement. Same thing with a buyer's agent. On the buyer agent side, I know a lot of times the first time the buyer talks to you, they may not quite be ready to move forward and even start looking at homes, but I think a lot of times you'll set them up maybe on MRIS, set them up with email alerts where they'll see listings or available properties, and that might, you guys know better than me, that might take 3 weeks for them to get ready. It might take them 3 months to get ready, but you can still continue to do those sort of things, and those would be considered ministerial acts. And then again, at the point when they're ready to move forward and you're providing real estate brokerage services, that's when you would enter into an agency agreement with that person, a written agency agreement.
Kathleen, a couple of questions have come through. It's Colette Massengale here. One of them we're actually going to cover when we get to the FAQs. This particular individual is saying in a recent agency class, he or she heard that buyers would work with a subagent or work as a subagent, or agents would work as a subagent with the buyer. They would provide the buyer with the agency disclosure form so that the buyer can acknowledge that they're a subagent or what have you. And then later on down the line, they want to switch hats. So we're going to cover that question a little bit later. And the other one was just some sort of understanding of why presumed buyer agency was eliminated.
Well, I think that might take the whole hour if we start talking about that. In general, I think there are some issues and concerns. I think in the past, from what I understand and what I have seen, I think an open house would be a perfect example. If a buyer came into an open house and the listing agent, this is again before October 1st, if the listing agent gave the understanding whom form to that buyer, basically saying, I represent the seller, sometimes the buyer really had no understanding of what was being discussed. They didn't understand agency. They didn't really understand the paperwork. Maybe didn't even take the time to read the paperwork, because I know some buyers thought that meant they were represented. If you would talk to the buyer later on, if something came up, they'd say, oh, yeah, I met with an agent and we filled out some papers. You know, they did not understand what the understanding whom form meant necessarily. And again, from the agent's perspective, this is not from the consumer perspective, but from the agent's perspective, I know a lot of times also you would be contacted by a friend from high school or a friend from the neighborhood who is kind of sort of thinking about buying a house or getting ready to buy. They'd want to ask you questions, you know, maybe I have some credit issues, how does that work? How does financing work? You know, you're answering the questions, they're picking your brain, they want to look at a couple of houses, you drive them around, you show them a house, you show them another house, you spend a couple weekends with them, maybe longer, and then when that person, your high school friend, your neighbor friend, whatever, when they get ready to make an offer, they go down the street and sign a buyer agency agreement with somebody else. So that's, admittedly, that is not consumer oriented, but from the agent's perspective, that was happening, and I know that happened more often than I would have thought. So I think going forward, having the signed buyer agency requirement, that does make it more clear, hopefully, to the buyer, where they understand, if I sign this agreement, I have an agent. I'm clearly represented. This person owes me fiduciary duties, the highest level of duties, obligation, loyalty. They're acting in my best interest. So I think that hopefully that'll be more clear to the buyer. And then also, hopefully, it'll help you guys not have to drive around your high school friends and then get kicked to the curb when they decide to go with somebody else, too. So, yeah.
Great. Did you want to add anything else about ministerial acts?
No, I think that was it.
Okay. So then we're going to go ahead. I'm going to kick it off with dual agency, talk a little bit about dual agency, and then discuss some of the changes with regard to agency disclosure. So single agent dual agency is still prohibited, and again, much of the changes with regard to dual agency are really just more technical in nature. You still need 3 licensees to engage in dual agency in Maryland. If you think about it like a triangle with the dual agent at the top, the dual agent would be the broker, or the broker could appoint a branch office manager to be the dual agent. So they would sit at the top of the triangle, and then the dual agent would appoint an intercompany agent, an agent affiliated with the broker to represent the buyer. That would be the intercompany agent for the buyer. And then another agent affiliated with the broker to represent the seller. That would be the intercompany agent for the seller. So 3 licensees for dual agency in Maryland. That has not changed. Dual agent cannot also be an intercompany agent, and again, that goes to the factor of being 3 licensees involved in the transaction. The dual agent sits at the top and appoints the 2 intercompany agents to represent the buyer and the seller. Intercompany agents must keep confidential information confidential, except to the dual agent. And Kathleen gave a great discussion of confidential information, the definition of it under the Brokers Act. As an intercompany agent representing a buyer, any information that they ask you to keep confidential, you must keep confidential. Same is true for the seller, except to the dual agent, as the law says. The consent for dual agency form, again, not very many significant substantive changes to the consent for dual agency form, so hopefully it's familiar to you. It can be signed when the buyer-broker agreement is signed or the listing agreement is executed. However, you know, at that time, there isn't actually a dual agency situation that has arisen. So you sign, you get the buyer to sign the buyer-broker agreement and the consent for dual agency situation agreement, and then you get the seller to sign the listing agreement and the consent for dual agency agreement. And then later on, let's say 2 or 3 months down the line, when there's actually a dual agency situation, then the seller would have to affirm their consent for dual agency for the sale of to a particular buyer, and then the buyer would have to affirm consent for the purchase of a particular property. And the affirmation hasn't changed. That aspect of the form hasn't changed. That's on page 2, at the bottom of page 2. Now, there was a little bit of tweak to the language. So it used to say prior to October 1 that intercompany agents may provide the same services. Under the new law, intercompany agents must or shall provide the same services to the client as the agent in a transaction that does not involve dual agency. So again, you have the fiduciary obligation to, if it's a buyer client, you protect and promote their interests just as you would if there was not a dual agency situation. All right, including advising them about price and negotiation strategy. So again, any of those things, any of those kinds of services that you would provide, if it wasn't a dual agency situation, you would provide as an intercompany agent. So dual agency within a team. So again, no real changes here. Dual agent can assign 2 members of the team as intercompany agents for the seller and the buyer in the same transaction. Of course, the caveat is that the parties have to first be notified prior to the contract being entered into that the licensees are in fact part of the same team and that the team could have a financial interest in the outcome of the transaction. So the parties have to sign that, agree to it, and then of course the team leader, team member may not be a dual agent in an intra-team transaction. All right, so there were some minor changes made to the notification of dual agency within a team form, but for the most part, that form is the same. Okay. A licensee can withdraw from representing a client who refuses consent to a disclosed dual agency. That hasn't changed. Doesn't limit the agent who terminated the dual agency from continuing to represent the client in other non-dual agency transactions. So again, no changes, substantive changes to the dual agency law here. If a financial bonus is offered to an agent who sells property that's listed with his or her company, then of course this information has to be disclosed in writing to each party. This is not new either, so this is something that hopefully you were doing prior to and will continue to do. Now we go on to agency disclosure and some of the more substantive changes. So talk about first contact. If it's not face-to-face, the seller's agent would disclose that you represent the seller, and the buyer's agent would disclose that you represent the buyer. And of course the disclosure would occur through the medium in which the contact occurred. So for example, if it was an email or a telephone call or something like that, then you would make the disclosure in the medium in which it occurred. At the actual first face-to-face contact, if the person is unrepresented, then you would use the understanding whom real estate agents represent form. And as Kathleen said when she was going over the summary of the changes, you provide the form or you present the understanding whom real estate agents represent form to unrepresented parties, right? So if you are a buyer agent and you're working with a for sale by owner, then you would provide the form to the for sale by owner so that they can acknowledge that you represent the buyer. Similarly, if you are a listing agent working with an unrepresented buyer or a subagent, then you would provide the form to the unrepresented buyer so that they can acknowledge that you're representing the seller. Okay. So just to reiterate, disclosure must occur to a non-represented party, not later than the first scheduled face-to-face contact with the seller lessor or the buyer lessee. If the buyer, seller, lessor, or tenant doesn't want to sign, then you would self-certify on page 2 of the Understanding Whom Real Estate Agents Represents form as you did in the past, so that hasn't changed. Now there has been a change to agency disclosure, as you probably know at this point, with regard to open houses. The Real Estate Commission has prepared a form that you are required to display in a conspicuous manner about the property. And this form advises or alerts prospective buyers that you, the person or agent sitting at that open house, represent the seller, and your fiduciary obligation is to the seller. If that buyer wants to have representation, then they can enter into a buyer agency agreement with a buyer. But really that notice is to alert buyers that you are representing the seller at the open house. When you post this sign in a conspicuous place, according to the statute, you have complied with your agency disclosure requirements at the open house. Right? And remember to prepare the form or post the form exactly as it was created by the Real Estate Commission.
Printed in color.
Yes, printed in color with that. There's some parts of that form that are in red. You want to make sure that you have it exactly printed in color as you downloaded it from the Maryland Real Estate Commission's website. Do you want to add anything to that, Kathleen?
No, I think that's clear. You've done a very good job, Colette.
Thank you. All right. All right. So just to reiterate, no form is required to be signed by a client with whom you've entered into a brokerage agreement. If you're a subagent, your fiduciary obligation is to the seller. If you're working with a buyer, then you want to make sure that you provide the understanding whom real estate agents represents form to that unrepresented buyer so that they can acknowledge that you represent the seller. If you are a seller's agent and there's no subagent or buyer agent, again, it would be an unrepresented buyer there. As a seller's agent, you want to give the agency disclosure form to the unrepresented buyer so that they can acknowledge that you represent the seller. And finally, if you are a buyer's agent and you're working with a seller, they don't have an agent, then you want to give the seller the understanding whom real estate agents represents form so that they can acknowledge that you represent the buyer. So that's pretty much the gist of the substantive changes with regard to agency disclosure. Okay. Did you want to go ahead and jump into some FAQs?
Actually, I was going to, before we start with the FAQs in the presentation, 2 questions came in, so I was going to just address those first, I think. The first question was, how can you be a subagent if you're required to have a signed buyer agency agreement? And that is a good question, and the answer basically is you can't. If you get the signed buyer agency agreement, then you are clearly the buyer's agent, you represent the buyer, and you're not a subagent. So if I'm understanding the question correctly, if you meet with a buyer, talk with them on the phone, whatever it is, and get the signed buyer agency agreement, then you're not going to be a subagent. You do not represent the seller. Your duty is to your loyalty, fiduciary duty, all that good stuff is solely owed to the buyer, and you do represent the buyer. So you are not a subagent in that situation. You only are acting as a subagent if you do not have a signed buyer agency agreement. So, I mean, the intent of the change was pretty clearly to encourage people to enter into buyer agency agreements and have buyer agency agreements signed. So that really it's the best protection for you as an agent, and it really provides the best level of services for the buyer, obviously, as well. You know, with the buyers, I think everyone agrees buyers deserve to be represented. So that really is what the intent of the law was. So if you have a signed buyer agency agreement, you would not be a subagent. That's the way that works.
Okay.
And then the second question was about ministerial acts. If you're performing ministerial acts, as an example, and the person signs with someone else, like say your high school buddy who's picking your brain and asking all these questions, if they end up signing a buyer agency agreement with someone else, what can you do? And further, if the person has signed, where am I losing my question here? And further, if the person has signed a buyer broker with you, and then they go with someone else, regardless if they closed, they signed, terminated and wrote a contract on property in the agreement, what do you do? So two parts of that question, basically. I think, Colette, feel free to jump in if you want to add anything. But I think the first part of it is if you're just talking to someone, a friend from high school, a friend from the neighborhood, you know, whatever it is, kind of giving them some general advice, then if they end up going with somebody else, honestly, I'm not sure that there's anything you can do. That's kind of one of the reasons why you would want to have a signed buyer agency agreement really as early in the relationship as you can, because without that signed buyer agency agreement, you don't represent them. And if they go and have someone else represent them, you know, then that other person represents them. I'm not sure that you have any cause of action. Depending on the facts, there may be a procuring cause issue. That, again, would be another hour-long discussion about procuring cause, so I don't really want to go into that. But in general, if you're giving the person some sort of general information about financing or credit issues or, you know, the neighborhood or whatever it is, if they end up going with somebody else, I'm not sure that you have any recourse at that point at all.
Right.
Yeah. And then if they do sign an agency agreement with you, presumably a buyer agency agreement with you, and they end up terminating it for whatever reason, and then go with another agent, that again depends on what how the buyer agency agreement reads. Sometimes there's a protection period in there if they, you know, purchase the home that you showed them within a certain time frame. they would still be considered yours technically. Sometimes there's language in there saying that their protection period does not apply if they sign another listing agreement with another licensee, with another real estate agent. So it depends on what your buyer agency agreement says. You may or may not have recourse against that person. And again, it often would be a procuring cause issue. And depending on what the facts are, who showed them the home, when did you show them the home, what exactly happened, you may or may not be the procuring cause in that situation. Because remember, procuring cause, just the fact that someone is being represented by an agent doesn't mean that that agent was the procuring cause. So that's really probably beyond the scope of this class, but you can contact the legal hotline or talk to your broker or office manager if you need more specific information about that. But you certainly should look at your buyer agency agreement and read the paragraph about terminating the agreement and what happens if the agreement is terminated to get a better understanding of that.
Yeah, I was just going to highlight that point as well about making sure, because if a buyer enters into an agreement with you and then goes and enters into an agreement with somebody else without effectively terminating the agreement, then yeah, that could raise some potential issues such as, breach of that brokerage agreement.
Right.
Any other questions? I'm not seeing any questions yet, so hopefully, Kathleen, if you're seeing questions, we can answer them as we go through.
Right, that's the only ones that I've seen so far.
Okay. Do you want to go ahead and start with the FAQs then?
Yes, we'll start with the FAQs.
Okay.
All right, FAQs. Okay. How many people does it take to engage in dual agency? We should have had polls for all of these questions. Pop quiz, everyone. No quizzes. How many people does it take to engage in dual agency? Everybody should know the answer to this. It is 3.
Yes,
and
the answer is 3.
Yes. And again, everybody keep in mind the example Colette gave is probably the best visual, or the best way to think of this is a triangle. 3 licensees with the broker or the branch office manager is at the top of the triangle, and then the base of the triangle we have an intercompany agent for the seller and an intercompany agent for the buyer. The broker cannot be an intercompany agent. So basically the short answer is you need 3 licensees, 3 warm bodies in order to have dual agency.
Yeah, so the only thing I would say, as I say all the time, if you work for a small company, you only have 2 licensees, then you can't engage in dual agency in Maryland.
Right. Okay. Where's it? May a sub-agent later become a buyer's agent for the same buyer on the same property? Actually, I'm just looking at the questions. It looks like.
Did I skip one?
I think, did you? Yeah, I think you did. No. Well,
oh, no, I didn't.
Sorry,
okay.
Yeah. May a sub-agent later become a buyer's agent for the same buyer on the same property? And the answer on this one is basically you should discuss that with your broker. Again, this law just came into effect on October 1st. So at this point, we do not have specific guidance from the Maryland Real Estate Commission on, everyone refers to this as switching hats. If you first show the property to the buyer as a sub-agent, they have not signed a buyer agency agreement, and then later on they want to put an offer in, they decide that they do want representation, they do want to work with you as a buyer agency agreement. So this question basically is, can you do that? Can you switch from a sub-agent to a buyer agent? And if so, how do you do that? So we don't have specific guidance from the Real Estate Commission on this point yet. Here at MAR, this has come up, and actually Colette has already been brought before the Statewide Forms Committee, and they are working on it. We don't have a form drafted yet or an addendum drafted yet or even any specific language yet, but that is on the agenda. I'm sure it's going to be discussed again at the next meeting of the Statewide Forms Committee. Again, that doesn't happen overnight. We work by committee. It has to go before the committee, be approved by the committee, and then it has to be approved by the executive committee. So it's a bit of a process, to be perfectly honest. So it's not going to happen overnight if or when it does happen. But in the meantime, please remember that as a sub-agent, your duty of loyalty is to the seller. You represent the seller. So as a sub-agent, you can't do anything that is against the seller's best interests. So that's kind of the key to this. Okay.
Did you want anything else about that?
No, I think we're good.
Okay.
The next question, I'm a buyer agent. when am I supposed to give disclosure to a seller as to my agency representation on behalf of the buyer? And for this one, basically the answer is it depends. Assuming that the seller is unrepresented, right? You do have to give the disclosure no later than the first scheduled face-to-face contact. If the seller is represented, then you don't need to at all. Remember, this disclosure only needs to be provided to unrepresented parties. So what that means basically in a situation, if you have a signed buyer agency agreement, you represent the buyer, the seller is represented by a listing agent, there's not going to be any of the understanding whom forms in that transaction, in that file, because both the parties are represented. There's no need to have those forms signed. All right.
Okay.
One question. Now that there's no presumed buyer agency, when do I need to get the buyer agency agreement signed? And that is before you provide any real estate brokerage services. So again, keep in mind the distinction between ministerial acts and real estate brokerage services. If you meet with somebody and they're not really ready to move forward, they're just sort of gathering information, you can talk to them, get their contact information, set them up. I think a lot of people do this. They'll set somebody up so they receive listings from MRIS. You know, the client will receive listings in whatever they've expressed a certain price range or a certain neighborhood they're interested or whatever. You can set them up so they receive automatic updates from you as to properties as they become available. That's an easy example. You can do that. But once it goes beyond that, if they want to start looking at properties, et cetera, then you would need to have a signed buyer agency agreement. All right. What duties does a subagent have to a buyer? And this is a kind of a long list. Remember, subagent's duty to a buyer, so that is a subagent's duty to a non-client, right? A non-client buyer, a buyer customer. The duties owed would be to present all offers in a timely manner, to disclose all material facts. Again, this is as it is today. Treat all parties to the transaction honestly, fairly, answer all questions truthfully, exercise reasonable care and diligence, account for all trust monies in a timely manner, comply with all applicable requirements of the Brokers Act and the Code of Ethics, comply with all applicable federal, state, and local fair housing laws and regulations, comply with any other applicable laws and regulations. Okay. What does it mean to have a client? How do I know who is my client? And a client is a person who has entered into a written brokerage agreement with a broker under a brokerage relationship. So again, that's just the key there. The presumed buyer agency has got, excuse me, there's no presumed, you don't have a client under a presumption of buyer agency anymore. It's got to be the written brokerage agreement. Okay, and remember the previous question was what duties would be owed to a customer, you know, a non-client. This question is what duties do I owe to a client under Maryland licensing law? And again, it's a fairly extensive list here. You have to act in accordance with the brokerage agreement. Obviously, that's a contract. You're bound by the terms of the contract. You have to promote the interest of the client by seeking a sale or lease at the price, rent, or terms, you know, specified or which are acceptable to that client. Unless otherwise specified in the brokerage agreement, you are obligated to present all offers and counteroffers to and from the client, even if the property is subject to an existing contract. Again, unless otherwise specified in your brokerage agreement. You are required to disclose to your client all material facts as well. And there's the second page here. You also have to treat all parties to the transaction honestly and fairly, answer all questions truthfully, exercise reasonable care and diligence, in a timely manner, account for trust monies, do the same as we have said previously, comply with the requirements of the Brokers Act, Code of Ethics, all applicable federal, state, local fair housing laws and regulations, any other applicable laws and regulations. This is additional here. You have to keep all confidential information confidential unless released in writing by the client, or unless your client agrees in writing. Yes, you can disclose, you know, this urgency or whatever the situation is. You have to get that in writing before you can release a client's confidential information. And then you also can perform ministerial acts. I think that is it. Is it required that we give the agency disclosure to attendees of an open house? This one I think everyone knows the answer to. This was one of the happy changes that everyone likes. No, you have to have the Maryland Real Estate Commission open house notice. That's that 8.5 by 11 printed in color notice form generated by the Real Estate Commission. you have to have that conspicuously displayed at your open house. So that's the requirement as of October 1st. Confidentiality, does it ever end? No. It only ends if your client consents in writing to the disclosure. So if your client doesn't want you to disclose some confidential information, you cannot disclose it. If they change their mind or they agree that it's okay, you can disclose it, get that in writing, and then you can share that information with the, with the other party. But in general, it's forever and ever. And again, remember, your client and every client of your broker as well.
Yeah, that's an important point.
All right. And now this one, everybody paying attention, this is the one where we're going to do the poll just to see what people think on this one. So pay attention. You do a listing presentation. You do not get the listing. However, during the course of the listing presentation, you learn that the sellers are divorcing and are very motivated to sell and have no loan on the property. The next week, you have a buyer client that shows an interest in the property. Can you disclose what you learned during the course of your listing presentation? All right, so you go do a listing presentation, the seller hires somebody else. So you're not the listing agent. You have a buyer who is interested in that property. Can you disclose to the buyer what you learned during the course of your listing presentation? How does this poll work? Oh, there we go. So if you're on your computer, sit there and click one and submit it. And I think Melissa can tell us the results.
Do you want to wait for the results, or you want to?
How long? Yeah,
We've got about 51% have voted so far.
Oh, good, good.
Okay.
All right. Analysts don't vote, Colette, so.
No, I'm not going to. I think I know the answer, though.
I think you do.
All right, we've got about 60, it's holding steady at about 64% voting. Do you want me to close it?
You want to close it, Kathleen?
Yeah, that's fine.
Okay.
Ready? Last chance? All right, I think poll is closed. 3, 2, 1, done. All right, so what do we think?
Are the results shown?
Yeah, 60% said no, 40% said yes.
All right. Wow.
Said no, 40 said yes?
Yes.
Well, here's the official answer. There is no agency representation at a listing appointment, thus there's no confidentiality under the Maryland Real Estate Brokers Act. It can be assumed, however, that the sellers had an expectation of privacy when speaking with you. Ethically and morally, silence would be appropriate. So the 60% go do a happy dance.
Yeah. I think the key there is that expectation of privacy. And even though you may disagree with the answer, I think you can understand why the thinking is ethically and morally silence would be appropriate. So.
Right. Okay. We have the next question here is, you are a listing agent who receives an offer from a represented purchaser, right? So your listing agent, sellers represented, buyers represented. The offer is sloppy and missing non-essential addenda. Can you refuse to present the offer to your client, the seller? Again, the answer to that is pretty clear. No, you have to present the sloppy offer and inform the seller what documents are missing.
All right. All right, so I'll go ahead. Colette here. You are buyer's agent representing two buyers. This also would be a great question to do a poll for. You're a buyer's agent representing two buyers searching for homes in the same price range in the same area. Both buyers decide to make an offer on the same property. Can you prepare both offers? And I've heard a myriad of answers on this, but the official answer is no. There is an incurable conflict of interest, and I think it's possible to, foresee that you could have a buyer, one of those buyers, feeling like, oh my gosh, another buyer that was your client was interested in the same property. Did you actually protect and promote my interest? So yeah, I think you see the rationale there, incurable conflict of interest. So the official answer is no. You're standing at the copier in your office. You hear a listing agent speaking about the dire circumstances of a seller. Is it all right to pass this information on to a buyer that you are representing? And I think this highlights the importance of the concept that we were talking about earlier. And Kathleen hit it on the definition of confidential information. You have to maintain confidentiality of your past and present clients and the past and present clients of the broker. Here you've got a situation where the seller is a client of the broker. So the answer is no, you would not be able to release that confidential information because it's about a past or current client of the broker. Okay. Your buyer's agent for a property under contract with a listing agent that is slow to return calls, provide required paperwork, etc. You're contacted by the seller who has also been unable to reach the agent with questions regarding the closing and progress of the contract. Is it appropriate to discuss this with the seller? All right, so your buyer's agent, is it appropriate for you to discuss anything with the seller directly? Of course, I think the answer is no. It's inappropriate to interact with the seller directly without the express permission of the broker who represents the seller. So I think that's pretty clear under both the Brokers Act and the NAR Code of Ethics. Communications should be agent to agent or broker to broker unless, you know, there's some exception that would apply under, for example, the NAR Code of Ethics. But generally the answer is communications agent to agent or broker to broker. You're a listing agent on a home and receive an offer from a buyer's agent. The buyer's agent calls and asks advice about what addenda need to be part of the offer and tells you that this is the first offer she has prepared. Is it okay to assist the new agent in what the contract should include? I think the answer is pretty clear there, no. You want to direct them to contact their broker or manager to get direction and guidance on what and how they should proceed and what they should include in the offer. Your buyer's agent preparing an offer for a home listed by a limited services brokerage firm. The listing requires you to call the seller directly to present offers. Is it your responsibility to explain the contract offer to the seller? What do you do? So you present the offer, but it's not your responsibility to explain the contract. You answer any questions, but you don't give any advice. And again, if they have questions about the offer, what have you, then you direct them back to the listing agent or listing broker. Next question, your listing agent, an investor calls to see the property. You make the appropriate disclosures. The investor wants to write an offer for 50% of the current asking price. Can you refuse to write the offer? So again, the answer here is all, and I think this is pretty clear. You present the offer to the client, any counter offers to the client unless otherwise specified in the brokerage agreement. So you present all offers, no matter whether they are lowball offers or whatever, unless otherwise specified in the brokerage agreement. You're the listing agent. You receive a call from a buyer's agent. The agent wants to run an offer by the seller. Can you refuse to do this because the offer is not in writing? All right, so the official answer here is that you must pass the information on. Now, obviously, for sales contracts of real estate, they have to be in writing to be enforceable in court, but the answer here is that you go ahead and pass the information on to the seller. Who knows where that oral, who knows where that it could end in a written agreement. So, your buyer's agent, you are part of a team. Can you represent a purchaser regarding another member of the team's listing? So, as we said earlier when we were talking about dual agency within a team, the broker may designate two members of a team as intercoming agents to the buyer and the seller in the same transaction if the parties, the caveat is, parties have first been advised that the licensees are in fact part of the same team and they could have a financial interest in the outcome of the transaction. The broker must ensure that parties have acknowledged in writing receipt of the notification of dual agency within a team form. So I was talking about that a little bit earlier, and then it needs that prior to designating two team members as intercompany agents in the same transaction. All right, so it is possible with these caveats and conditions, as long as the broker does this, gets the parties to acknowledge this, does it prior to designating the two team members, then it could be done. I'm an intercompany agent representing the buyer in a transaction. All disclosures and forms required by law have been signed. The listing intercompany agent is going on vacation and will be gone when some inspections are scheduled. The listing agent has asked me to handle the inspections and negotiate directly with the seller while he's gone. Can I do this? Not a good idea. Best thing to do in this scenario is to have the broker branch office manager appoint another agent to represent that seller while the listing agent is gone on vacation. Okay. How do you get the for sale by owner to pay a commission without establishing an agency relationship? I think this is a great question. So the answer is compensation and agency are two separate things. A licensee can enter into a compensation agreement with a seller that does not, and again, the key there is does not create an agency agreement. The licensee should also have the seller acknowledge that the licensee represents the buyer. So you can enter into a compensation agreement, but that doesn't create an agency relationship, and that's permissible under Maryland law. Now, usually, I think there are authorization to show forms that companies have prepared for those scenarios. Next question, what is a material fact? Material fact in real estate is well defined as a fact that affects the value of the property or would affect a buyer's or seller's decision whether to buy or sell or the terms and conditions on which to buy or sell the property. So raise that question so that it makes it clear under Maryland law, real estate licensees are obligated to disclose material facts that they know or should know that relate to the property as distinguished with confidential information, which you must maintain. So if you've got confidential information about a client, you must maintain that confidentiality. Very different term here, material facts, you have to disclose those. And sellers also are obligated to disclose known latent defects. So two different disclosure obligations, material facts disclosed by licensees, known latent defects disclosed by sellers. What if someone asks you a specific question about a property as to whether someone was murdered or died or something that's public knowledge but not required to be disclosed? How do you answer that question? So the Brokers Act actually has a specific provision that says that it's not a material fact that a homicide, suicide, natural death, accidental death, what have you, occurred on the property. You're not obligated to voluntarily disclose that. So what do? You can suggest or recommend that they check the public records regarding the property or the event. So that is the official answer to that question. Did you want to add anything, Kathleen?
Well, we do have some questions that came in, so I was just going to go ahead and see if we can go through some of those.
Okay,
hopefully
sure.
all of those.
Okay.
First question, let me see. How can you be considered a subagent if the seller hasn't indicated they accept subagency in their listing agreement? I think I would say for this one, if you're using the MAR forms, the exclusive right to sell listing agreement, that actually does authorize subagency. I don't know if everybody's aware of that or not, but in the compensation paragraph, there is language in there where the seller authorizes someone to show the property as a subagent. Someone could show the property as a buyer's agent or a subagent. I think, quite frankly, the seller probably doesn't care as long as people show the property. So that language is in the MAR listing agreement right now.
That's correct. Yeah, there is a provision that talks about cooperating and compensating buyer agents and subagents.
Right, right. So that's in the MAR form. If your brokerage has tweaked that a little bit or has customized forms, you probably should talk to your broker or your office manager about that. But if you're using the MAR form, then subagency is authorized. So hopefully that will not be an issue. All right, let me go on. We're getting some more questions, and I'm going to move on a little quickly, I think. The next question is, I continue to receive understanding whom agents represent forms in offers. I've explained it's no longer needed. The buyer's agent said it is, which is incorrect. Should I have my manager or broker call their broker or manager to review the new agency laws?
Yeah, or have them call the legal hotline, right? I mean, as we have been saying, under the new requirements, the agency disclosure form or the understanding whom real estate agents represents form is you're only required to provide that to unrepresented parties. So if there's some confusion about that, there could be a broker-to-broker conversation about it, or you could direct them to call the legal hotline.
And I'm hoping that this is just sort of a transitional issue and a learning issue or a training issue, because who submitted the form, Margaret, you are absolutely correct. It is no longer required, and we're trying to push that message out when we do classes, push that out to the brokers and office managers so they will understand that the form is no longer required. And I think as time goes by, hopefully more people will be informed, and that should resolve itself, I would hope.
Yeah, so unrepresented parties, agency disclosure provided to unrepresented parties.
Correct. Okay, next question. I understand you do not need to provide the form to a potential seller at a listing appointment when the seller will be interviewing other agents. true. That is correct also, because remember, if the seller is interviewing, say, 3 listing agents, the understanding whom agents represent form, basically you're disclosing who you represent. And if the seller hasn't signed a listing agreement with you, you don't represent anybody. So there's nothing to disclose.
Right.
So that is correct. You do not need to give that to the seller at that point, because you don't represent anybody. And again, if the seller interviews 3 listing agents, they love you, they signed the listing agreement with you, then at that point you still don't need to give it to them, because at that point they are represented and you represent them. So the understanding whom form, the bottom line here, the underlying concept here, the understanding whom form is going to be utilized a lot less frequently than it is now. The good, bad, whatever it is, I think that's the way this is going to play out, and that's, again, like we said, a learning point. I think people will get more familiar with that as we move forward. But you are correct. You do not need to present this at the listing appointment if the seller is going to be interviewing other agents, because you don't represent anybody at that point. There really is nothing to disclose.
Yeah, and I think as we go through and more, licensees are taking the new agency class, hopefully the understanding of when you need that form will become clearer.
Right. Okay, let me go to the next one. This is actually the same question. All right, good. If a buyer and seller have both signed dual agency forms separately when entering into agency agreements, then a contract is formed and dual agency is the case, do both dual agency forms need to be a part of the contract? Or is only one form needed, fully filled out by buyer and seller? I was recently asked to submit both fully filled out forms. Colette, you want to talk about that? That was kind of your...
Yeah, so if you look at the actual text of the Brokers Act, so once let's do the seller, for example. If the seller signs the listing agreement, then they sign the consent for dual agency form, there's no actual dual agency situation that has arisen, and then let's say a couple of months down the line, there is a dual agency situation, so you get the seller to affirm consent for dual agency, and then the forms, both the brokerage form and the consent for dual agency form go in the file. They go in the file, okay? There's nothing in the Brokers Act that requires that you give a copy. You can, just so that, there's clarity that everybody is kind of complied, but there's nothing in the Brokers Act that requires that you give copies of the consent for dual agency form to the other party. Now, you can, just so that everybody is on the same page and understands that consent for dual agency has been signed, but there's nothing that requires that you give a copy of it to the other party. It goes in the file. You want to add anything to that, Kathleen?
No, I think that's fine. Although, again, dual agency situation, you're both going to have the same broker, so, if that's your broker's policy for whatever reason,
Right.
I guess it's your broker's policy, but it is not required by law. Colette's point is correct. All right, let me see the next one. Okay, sorry.
Oh, no problem. I can barely see the questions.
Okay, if I have no, here's the question. If I have no signed buyer agency agreement or representation agreement, my screen just jumped. I apologize. All right, if your broker, here, let me go through this, I'm sorry. If your broker is the listing broker, but you are not the listing agent, and an unrepresented buyer would like to see and later wants to buy the house, are you a sub-agent?
No, you're a seller's agent. The definition of seller's agent under the Brokers Act is a licensed broker who, in accordance with a written brokerage agreement, acts as the listing broker for real estate, or a licensed associate broker or salesperson who is affiliated with the listing broker. So you are a seller's agent. Remember, a sub-agent, you're not affiliated with the listing company. Okay, so you would be showing that property as a seller's agent. Want to add to that, Kathleen?
No. I think that's fine. Again, that's really kind of important to remember, and I think I'm not sure everyone understands that, or maybe I didn't emphasize that. I think because I've been asked that a couple of times, but subagent, you are not with the listing brokerage, you're with a different company. That's kind of
Yeah, and I'll reiterate the definition. Look, the definition of seller's agent as defined under the new law, again, means a licensed real estate broker who, in accordance with a written brokerage agreement, acts as the listing broker for real estate, or a licensed associate broker or licensed salesperson who is affiliated with the listing broker. That is the definition of seller's agent under the law.
Okay. All right, next question is there a one-pager of your FAQs? You flew through them too quickly. I seem to disagree with some of the responses. I would like to make sure I'm doing the right thing. Melissa, I don't know, do we send this presentation to everyone? Or
It's going to be posted. It'll be posted,
the webinar
right?
itself will be posted, yeah, and we can post the one pager with FAQs. We can easily get that up onto the website and send it to everybody that is participating in the webinar today. That's not a problem.
Okay, good, good. So hopefully that'll help everyone. All right, go up again. I think, is that it?
Did we get everything?
Can't be it. I think that's it.
We've got a couple more. Just to clarify once before we've signed the agency listing or buyer, we do not need to include copies of understanding agency with submitted offers.
That's correct, you do not. If the parties are represented, you have a signed buyer agency agreement with the buyer, there's a signed listing agreement with the seller, the understanding whom form, you won't even have one.
Right.
So there's nothing to send.
Next question is what if there are multiple offices for the broker? Would that agent still be the seller's agent?
Yes.
Yes. 1, 2, 3, yes.
Yeah.
For everybody that's asking, the presentation will be posted at our website, which is mdrealtor.org, and that'll be up probably middle of next week.
Anything else, Melissa?
No, that's the last of the questions that we've gotten in. Do you guys have anything else?
No. I hope that it was informative and helpful for, this is Colette, I hope it was informative and helpful for people. If you've got any additional questions, feel free to call the legal hotline.
Very good. We will, like I said, we've been recording this, and we will be posting it to our website probably the middle of next week. We will send an email to everybody that participated today once the webinar is up to let you guys know that you can view it. And that will stay up indefinitely, so you can refer back to that as long as the information contained within stays current. If it happens to change for some other reason, then we'll obviously update that information. We thank you for joining us today, and we wish you a very happy holidays.